Hello everyone, and welcome to our webinar on addressing the International Data Transfer Challenge, which is about the new European data transfer tools, the requirements in Asia, and what organizations need to do in response to those requirements. I'm Oliver Yaros, and I'm a partner in Mayer Brown's London office. And today I'm joined by my colleagues Ulrich Worm, who is a partner in our Frankfurt office, Karen Lee, who is a counsel in our Singapore office, and Vivek Mohan, who is a partner in our Palo Alto and San Francisco offices. We are all members of the Cybersecurity and Data Privacy Practice, which is a team of international lawyers within Mayer Brown that is able to support our clients on any cybersecurity and data privacy matter anywhere around the world. As I mentioned, today's webinar is about how organizations should address the International Data Transfer Challenge. In today's world, businesses in all sectors are increasingly reliant on the free flow of data across borders to operate their multinational businesses, engage IT service providers and outsourcing service providers, and to trade goods and services with counterparties around the world. Whether that data consists of personal data about employees for HR purposes, personal data about individuals, customers and suppliers they deal with, financial data, or supply chain data. But over the last decade, and specifically over the last few years, there has been a growing trend in many jurisdictions, and in Europe and Asia in particular, towards adopting increasingly tough and often conflicting measures that seek to localize the storage of data and limit the free flow of data from these territories across borders, which presents a real challenge for businesses looking to share data internationally in the context of operating their businesses across the globe. Today, we'll be looking at the trends in the requirements as far as the European landscape is concerned, and how to comply with the changes coming through in Asia. And finally, what steps businesses need to take to address those challenges. I will now hand over to my partner, Ulrich Worm, to talk about the EU requirements.
Thank you very much, Oliver. I think by way of recap, that it would make sense to briefly talk about the implications of the so-called SHRAMS 2 decision of the Court of Justice of the European Union. Because this decision was the actual starting point of the latest developments in Europe around data transfers. So what is SHRAMS 2 about? The SHRAMS 2 decision concerns data transfers from the European Economic Area to third countries. More specifically, it concerns data transfers from the EEA to the United States of America on the basis of the so-called EU-US Privacy Shield, or on the basis of standard contractual clauses. It's worth noting that data transfers from Europe to any third country are only admissible if they can be based on a safeguard listed in Article 46 of the GDPR. These safeguards include adequacy decisions, which, broadly speaking, confirm that a level of data protection in the country to which the data shall be transferred is adequate. Binding corporate rules, which, again, broadly speaking, provide for legally binding data protection rules for data transfers between members of a group of undertakings, and standard contractual clauses. If none of these safeguards is available, transfers may, but only by way of exception and under very strict conditions, be based on so-called derogations for specific situations. Against this background, many companies relied on the EU-US privacy shield and or standard contractual clauses for their data transfers from Europe to the United States. In the SHRAMS 2 case, the Court of Justice of the European Union decided that the EU-US privacy shield does not establish an adequate level of protection in the United States and can thus no longer be used to transfer personal data from Europe to the USA. The court further held that standard contractual clauses continue to be an instrument under which transfers of data from Europe to a third country could be justified. However, the court stressed that parties wishing to rely on standard contractual clauses must verify whether the level of protection in the third country is adequate. If the level of protection would not be adequate, the court pointed out that appropriate supplementary measures, in addition to standard contractual clauses, could be implemented in order to protect the data. Such supplementary measures must be able to ensure that foreign domestic law in the country to which the data is exported does not, as the court has put it, impinge on the adequate level of protection. Importantly, the court has not discussed in detail which supplementary measures could be taken, which left companies wishing to export data in uncertainty. Following SHRAMS 2, the European Commission adopted new standard contractual clauses for data transfers on the 4th of June 2021. The new standard contractual clauses replace controller to controller and controller to processor standard contractual clauses, which were adopted prior to the GDPR and which remained in force after the GDPR entered into force. So essentially, the new SCCs replace the standard contractual clauses we have been used to over the last couple of years. The new SCCs follow a modular approach. This means that there are several modules in the new SCCs which aim to address different scenarios. For example, there is a module for controller to processor transfers. This module comprises the rules which would normally be laid down in a data processing agreement between the controller and the processor. So the new SCCs obviate the need for a separate data processing agreement, which certainly is a good thing as it helps to make the overall contractual documentation less complex. The new SCCs require both of the data exporter and the data importer to assess the local laws in the jurisdiction to which the data shall be exported. Such assessment, of course, needs to focus on the vulnerability of the data in the export country. The new SCCs require that technical and organizational measures are taken to protect the data in the export country, and require that such technical and organizational measures are specifically described in these standard contractual clauses. Finally, the new standard contractual clauses impose obligations on the data importer in cases where public authorities have accessed the exported data or request access to the data. Finally, it's important to note that companies will have 18 months to replace their old standard contractual clauses with the new set of standard contractual clauses. While the new standard contractual clauses can help to put data transfers on a solid legal basis, the new SCCs do not provide a comprehensive answer to the questions which SHRAMS 2 created, by requiring that supplementary measures to protect data might have to be taken without exactly specifying in which cases such measures need to be taken and how such measures could look like. To address these uncertainties, shortly after SHRAMS 2, the European Data Protection Board announced that it was looking into this question and would provide further guidance. And after publishing a draft guidance paper open for public consultation, the final guidance was issued just a few days ago on 21 June 2021. So what does the EDPB guidance paper say? First of all, companies wishing to wishing to transfer data from the EEA to a third country shall conduct a local law and practices assessment in the jurisdiction where the data is transferred to. Such assessment is called a transfer impact assessment and shall cover not only the local law in the export country, but also the practices of authorities in such countries. The EDPB guidance further advises companies to implement supplementary measures to protect the data if the assessment of the local laws and practices in the export country reveals so-called, quote, problematic legislation, unquote, or that the data is otherwise not sufficiently protected in the export country. The guidance stresses that supplementary measures must be tailored to address the deficiencies identified through the local law and practices assessment. So there needs to be a connection between the measures and the results of the assessment, such that the measures are able to address the deficiencies which have been identified. The EDPB guidance specifically discusses encryption and pseudonymization as appropriate supplementary measures. And in particular, the guidance discusses the strength of encryption keys and the precautions which need to be taken in the context of pseudonymization to avoid that the data can be traced back to a data subject. The guidance stresses that if supplementary measures are necessary to protect the data, but not possible to effectively implement, then the transfer would not be lawful, unless it could be based on an Article 49 derogation, which, however, as stressed before, are only applicable in very exceptional cases and under strict conditions. So, in light of the new guidance, what should businesses be doing now? First of all, companies should map all international data transfers they undertake. This is a concept often referred to as know your transfers, and this needs to be the starting point. Then you would need to identify the legal basis on which a transfer relies. And if there would be more than one transfer, which often is the case, then that analysis needs to be undertaken for each of the transfers, which might reveal that one transfer is based on a legal basis different from that of other transfers. Then companies would need to carry out the local law and practices assessment I already spoke about. Naturally, this might require companies to hire outside legal counsel to advise on the local law in the export country. It's worth noting, though, that the EDPB guidance contains links to information sources which companies could use to make a self-assessment. Depending on the deficiencies identified through the law and practices assessment, and how such deficiencies could be addressed, companies would need to adopt supplementary measures as required. Such measures might comprise and are certainly not limited to encryption and pseudonymization. Given that the new set of standard contractual clauses has been published earlier this month, companies will also have to renegotiate their existing standard contractual clauses and other agreements with service providers as required. Very importantly, companies are advised to properly document each of these steps above, in particular as it concerns the local law and practices assessment and the conclusions drawn therefrom. And last but not least, since laws and practices can change over time, companies will need to re-evaluate their analysis on a regular basis. And now back over to Oliver, who will give an overview about the UK requirements.
Thank you, Ulrich. So, what is the picture in the UK, you might ask? Well, since Brexit and since the end of the Brexit transition period, which finished at the end of 2020, a new regime now applies in the UK. The UK has its own form of the GDPR instead of the EU GDPR. What this means is that international businesses that transfer data from Europe in places that includes the EU and the UK now need to consider both those territories as being separate jurisdictions. Two different regimes apply. As far as transfers from the EU to the UK are concerned, well, the EU has given the UK an adequacy status. So that means that the SECs that Ulrich mentioned do not need to be entered into for transfers from the EU to the UK. But this adequacy status has a 4-year sunset provision. That means that in 4 years' time, it will be reassessed by the European authorities. So it is watch this space as far as that is concerned. In terms of the law that is applicable, well, old EU case law and guidance that was adopted before the end of the transition period is still applicable. So the SHRAMS 2 decision and other case law and finalized guidance still applies. But new EU case law and guidance, including the EDPB recommendations, the final version of those Ulrich was talking about earlier, those are persuasive only. So the UK is going to be adopting its own guidance and will have its own case law. And so in future, it is quite possible that the way in which the two regimes are practiced begin to diverge, because the UK GDPR at the moment is fundamentally the same as the EU GDPR, but how it may be interpreted may change over time. And we've seen this in particular with respect to international data transfers. So, for example, as Ulrich mentioned, new EU SECs have been adopted for transfers from the EU, but the UK has said that it is going to issue its own standard contractual clauses for transfers from the UK going forwards. At the moment, the old SECs are still applicable, but new UK versions of those will apply going forwards together with the ICO's guidance on international transfers. So what that means is that for international organizations that transfer data from both the EU and the UK, separate mechanisms are likely going to have to be adopted for transfers from the EU and from the UK, and different assessments may need to be made. Now, of course, it may well be that the UK approves the new EU SECs for transfers from the UK in the future, but at the moment it is unclear whether that is going to happen. And importantly, it should be mentioned that although the UK has EU adequacy for transfers from the EU to the UK for a 4-year period, that can change. The EU is going to monitor the UK regime and the agreements that the UK enters into with other countries as far as data transfers are concerned. And there may well be changes in that status, particularly as a result of case law in the EU within the 4-year period. So at the end of the day, what international organizations need to think about is that the EU and the UK are now separate regimes, and data transfers from both those territories now need to be considered differently because different requirements may apply, different mechanisms in terms of contractual mechanisms may need to be used to get data from the EU and the UK, and different assessments may need to be made to address the implications of the due diligence requirements that flowed from SHRAMS 2. So an increasingly fragmented and possibly divergent practice as far as data transfers from Europe may apply. And with that, I'm now going to hand over to my colleague, Karen Lee, to talk about the picture about compliance in Asia and the restrictions that can pose challenges there.
Thanks, Oliver. So there have been lots of new developments in the APAC region recently. This map just illustrates some of them. Many jurisdictions are either proposing amendments to their current data privacy laws or working towards introducing their first overarching data privacy law, such as China, India, and Vietnam. Generally, we see an overall shift with jurisdictions trying to align their local laws to more GDPR-type standards. For example, introducing mandatory data breach notification obligations. So these have already recently been introduced by Singapore, Japan, and New Zealand. And Malaysia and Hong Kong are in the process of considering such amendments to their own data privacy laws. We're also seeing an increase in powers being granted to local privacy authorities and penalties that are payable for a breach of the data privacy law, including tying them to revenue-based penalties. So for example, in Singapore, fines can now be up to 10% of the company's annual turnover. More countries in the APAC region are also looking to obtain adequacy decisions under the GDPR. So far, only Japan and New Zealand have adequacy decisions, but South Korea have recently proposed new changes to the data privacy law with the specific aim to achieve an adequacy decision. This table shows a brief overview of some of the jurisdictions in the region and whether they have cross-border transfer restrictions or data localization requirements. So a few years ago, there was a real uptake of data localization requirements in the region, for example, China, Vietnam, Indonesia, and India. But over the last couple of years, the requirements have been pared back a little, except for China. So for example, in Indonesia, it used to be that any operator of an electronic system, whether private or public, must have a local data center and store data locally. Now, due to changes that were introduced in 2019, this only applies to electronic system operators that provide public services. So this includes public bodies and entities appointed by public bodies to operate their electronic system on their behalf. However, for China, it still has a data localization requirement and has stringent cross-border transfer restrictions, which have been broadened by the new data security laws and draft personal information protection law. So I'd now like to focus on providing an update on China, as it's always a jurisdiction of great concern and because of stringent requirements and complex matrix of laws. As a brief recap, China does not currently have a single comprehensive data privacy law. Instead, it's subject to a piecemeal approach, with the main law being China's cybersecurity law. So the cybersecurity law applies to network operators and critical information infrastructure operators. With network operators, this is essentially any business that owns or operates an IT network, servers, or websites in China. So it has a really broad application. Regarding CII operators, this is broadly defined as any sector which, if affected by a malfunction or a data leak, could lead to serious damage to national security or economy, people's livelihoods, or public interest. So some sectors have actually been specifically identified as falling within the definition of a CII operator. These can include the finance industry, utility providers, media platforms, e-commerce platforms, e-payment platforms, big data providers, cloud computing providers, and providers of enterprise systems. Under the CSL, CII operators are subject to data localization requirements, which means they must store all personal information and important data onshore. And if they need to transfer data overseas due to business requirements, they must conduct a security assessment in accordance with measures that have to be established by the relevant government authority, which are still being finalized. Back in June 2019, the latest draft measures on security assessment of cross-border data transfers of personal information had been issued, and it was meant to introduce cross-border transfer regulations that sit under the CSL, and was meant to apply to both network operators and CIA operators. Some of those requirements include, gaining consent of individuals before cross-border transfers of data and applying for an official security assessment. But the cross-border transfer measures are still in draft format, and they have not yet been brought into operation. And it's likely that these measures will be substantially amended in light of the newly passed data security law and the draft information protection law to bring them in line. While we do talk about, when we talk about data privacy law, the focus is usually on the cybersecurity law, but it has to be remembered that there are sector-specific regulations that also apply, as well as non-binding national standards that are issued and which the PRC authorities and courts do take into account. So now I want to look at the new data security law, which was recently passed on the 10th of June this year and will come into operation on the 1st of September. The data security law sets out a framework to regulate the processing of data, which is defined as any record of information in electronic or non-electronic form. So it goes beyond personal information. For example, data or information that's generated by your company in the operation of your business. A provision in the data security law does state that those who carry out data processing activities that involve personal information must comply with the relevant laws. So it implies that the data security law may potentially not apply to personal information, which could be covered by the draft personal information protection law once it's enacted, but further clarification will likely be provided on whether this is the case. So in relation to cross-border data transfers, the data security law regulates overseas transfers of important data, and it distinguishes between CII operators and non-CII operators. So CII operators will remain regulated under the CSL and have to follow any rules and measures that are set out under the CSL, which have to still be established. For non-CII operators, they have to conform to any requirements that are formulated by the government authorities for overseas transfers of important data. These regulations concerning cross-border transfers of important data will likely be released over the course of this year, and it's something that needs to be looked out for. But based on previous draft measures issued under the CSL and the draft personal information protection law, the regulations will likely require some form of official security assessment. So the issue with important data is that while the concept originally was introduced under the cybersecurity law, the definition is still not clearly made out. It's not clearly defined yet what it constitutes. But one important key takeaway point is that your obligation data security in China and cross-border data transfers will not be limited to personal information. It could apply to other business data. I also want to just highlight another important provision regarding cross-border data transfers that's introduced by the data security law. If a foreign judicial or law enforcement authority requests access to data that is stored in China, whatever that data may be, that data cannot be provided to them unless the relevant Chinese authority has granted its approval or a relevant international treaty applies. Any breach can result in a maximum fine of about $780,000 and other penalties, for example, suspension of services and revocation of business licenses. Any individual seen as directly responsible could also face a fine. This, of course, places foreign companies in a very difficult situation because if you comply with the foreign authority's data access request, it could render you in breach of the data security law, but non-compliance may result in you being in breach of the relevant foreign law court order. So on 29th of April 2021, the second draft of China's Personal Information Protection Law was released. Once passed, it will become China's first comprehensive law that protects personal information. It's important to know that under the current draft, any cross-border data transfers of personal information requires the consent of the data subject. So this seems to be the case even if other legal grounds for processing apply, for example, where transfer is necessary to perform a contract. and regardless of whether or not the transferor is compliant with the other cross-border transfer requirements, which I will discuss in a moment. And in order to obtain the consent from the data subject, you need to provide a certain amount of information. So, for example, notifying them of the actual identity and the contact information of the recipient, the purpose of processing, the processing method, the type of personal information being transferred, and how they can exercise their rights under the draft personal information protection law. Under the draft law, CII operators and any entity that processes personal information at a volume that exceeds a certain threshold that has to be specified by the Cyberspace Administration of China must store personal information onshore. So this is all personal information that's generated or collected in China. It's also, if it is necessary for them to transfer this personal information outside China, then they have to pass an official security assessment organized by the CAC, and they need to obtain the consent of the data subject. So it's quite onerous. The draft also imposes general restrictions on cross-border transfers of personal information by any other entity, even if they are not a CII operator or a large volume processor. So in essence, no one can transfer personal information outside of China unless it obtains the data subject's consent and one of the following conditions is met. So either a security certification is obtained, which is conducted by an accredited body, or an agreement with the foreign recipient is entered into, which is based on the standard contract that's in the process of being drafted by the CAC, which must ensure that personal information is protected to the same standard as that provided under the draft PIPL. All the transfers in accordance with other laws or regulations, other conditions prescribed by the CAC. So it's important to note that there is currently no concept of like the binding corporate rules or exceptions in relation to intergroup transfers. A prior risk assessment must also be conducted by all data controllers in relation to any cross-border transfers. And records of the risk assessment must be retained for at least 3 years. The draft personal information protection law, just like the data security law, also prohibits the transfer of personal information requested by foreign judicial or law enforcement authorities unless the transfer has been approved by the relevant Chinese authority or it's in accordance with relevant international treaties. So that's a lot of information to take in, but overall, the data security law and draft personal information protection law has expanded the data localization and cross-border transfer requirements that were introduced by the cybersecurity law. So now all cross-border transfers of important data by any entity, not just a CII operator or a network operator, will be subject to regulation. And once the draft personal information protection law is enacted, all cross-border transfers by any data controller will be subject to restrictions. And any entity in any sector that processes personal information above a certain volume must store that data in China and obtain a government security assessment to transfer it outside of China. I'd now like to hand over to Vivek, who will take you through the next part.
Thank you, Karen. Well, you've had a great overview of some of the key developments in Europe and in Asia. We wanted to use the remaining time in this presentation to talk about some practical steps, some things for you to consider as a company as you think about how to comply or how to respond to these developments. The first step, before even diving into the weeds of these laws, is to understand your company, understand your posture, understand how your business is structured, where you have geographic exposure, where you collect or process data, whether in the customer or in the employee context. Understand the roles and responsibilities you play for that data, whether you're a controller or a processor. And just really getting a good handle on your business, understanding whether you're subject to sector-specific rules, whether inside or outside of the data protection or data security context, and understanding what your interactions have been with law enforcement or government agencies, whether you have received legal process, whether you have been required to hand over personal information in response to such process, and how you would respond to such a request if you did receive it to the extent you have not. These are really important threshold questions to get your hands around before developing a strategy to comply with these laws and these new obligations. Because once you understand what laws actually apply to you and what provisions of those laws are most likely to be significant for your business, you can start to think about what a strategy is going to look like. But before we get to more specifics, we just wanted to kind of empathize. We feel your pain. We know that this has been an area of the law that has absorbed a lot of your time over the last several years, from the fall of the EU-US Safe Harbor to the enactment of Privacy Shield, to the fall of Privacy Shield, to implementing the first batch of standard contractual clauses, or maybe for some of you that you've had that in place for quite a while, to these new clauses, to the vast round of recontracting done in advance of GDPR, as well as for those of you with US exposure, and in California in particular, for California's Consumer Privacy Act. This has been a wave after wave of recontracting with new obligations and different sets of terms, and not just outbound contracting. You've also had to receive and deal with all of these different forms and really try to figure out what you can commit to and what you need to respond to. And this has been a really painful process over the last several years. We just wanted to say, we get it. It's exhausting. Hopefully, we have some tips in this conversation that will help reduce some of the churn, but we cannot promise that any of it will be completely a silver bullet. So with that in mind, many of us are, look at this as just another round of recontracting, but there are some silver linings. The new clauses are modernized. They reflect, of course, GDPR as opposed to the long dated data protection directive. But there's some features in it that really exist to help businesses that allow for forward-looking flexibility and take into account certain realities of the corporate world, such as changing corporate forms or additional parties to the agreement. And we'll get into that in just a moment. So just to kind of reframe us, what we'll talk about are how to think about the new standard contractual clauses, as well as a few tips on how to think about the data localization trends and cross-border data transfer restrictions that Karen covered. And we'll try to cover these in turn. So first, we'll talk about the timeline for the new clauses, key features of them, and then how to prioritize these your compliance strategy. First, as we all know, the clauses were made available last week. September of this year is the last day for companies to use the old clauses for new transfers of personal data between the EEA and ex-EEA. And very generously to us, just after Christmas next year, the deadline for the old clauses to be fully replaced. So what I think we can read backwards from this is that the next year is going to be next year and a half is going to be a very busy time for companies to develop new data processing addendums / completing the draft clauses with representations they feel comfortable with and making these available to their business partners, which means that both you are going to be sending these out and you're going to be receiving these en masse. So we do have some benefits, as I mentioned earlier, in the new clauses. There is a relatively more simple and aligned to the existing framework set out in GDPR set of choices. Going back to my initial point, understanding your business and understanding whether you're a controller or processor of personal data in any particular context or for any particular relationship allows you to choose which set of clauses apply. The new clauses cover all 4 scenarios, which is very helpful and is an upgrade from the prior set of clauses, which required a little bit of creative thinking in certain contexts. And these new clauses allow multiple parties to contract. So you can add new parties over time, which is particularly helpful when either corporate forms change, either intra-group, or you have additional parties to an existing agreement. This provides a little bit more flexibility, particularly given the difficulties of implementing these contracts in practice when complex business negotiations have already taken place. So thinking about, you have these new clauses in front of you, you have all of this language and this kind of intractable set of challenges of how to get your entire vendor population or your commercial counterparties onto this new paper. The first thing to do is just really start to understand your processor and sub-processor landscape better. To the extent that you are a controller of data, develop a risk-based prioritization based on the role that your commercial counterparties are playing, their importance to you as a business. And this comes down to a number of factors that are going to be specific to you as a business. What is your most sensitive personal data? What is the data that you collect and process? And in what context do you share it with other parties? And this is something that I think is important to not just have legal representation in coming up with this list. I think it's important to work with business partners to really understand what are sensitivities to the business, where is information considered vital, and where is such sharing considered to be something that not only has legal risks or potential legal impact under GDPR or other frameworks, but also reputational risks. What is data that you feel that you want to make sure you are giving the 1A prioritization to? And developing that framework of the types of vendors, the roles that they play, and then working off of that list in priority order is, I think, the best way to make sure that you achieve the goals that are responsive and relevant, not only to the legal obligations, but to your business priorities. This also can be informed by where your business actually has geographical exposure, whether you are based in Europe or the United States or otherwise, what your exposure is to European data transfers, and the sector that you're actually in, and what those specific requirements may mean for things like the specific technical safeguards that are included in the standard contractual clauses. We recommend as well that companies that are positioned to do so think about creating a new data processing addendum template. And this is something that is actually broader than a European compliance measure. We think that this is the most effective way of trying to look around corners a little bit. In the United States, we've had a number of legal developments, as I mentioned earlier, CCPA in California. The state of Virginia has enacted a new privacy law that is slated to come into effect in 2023 that has certain GDPR-like requirements. And we're seeing only more movement internationally. Of course, those of you that have exposure in Latin America are familiar with LGPD in Brazil. We think that one of the best ways to try and capture this is to create a new template that reflects some of the key requirements under these laws to the extent they are applicable to your business, and then follow that with the standard contractual clauses filled out in a manner that makes sense for you as a business. So creating that as a separate agreement that captures basically all of the privacy, data protection, data security terms that you need to have in place with vendors, extracting that to the extent reasonably feasible from your master services agreement or the other types of agreements that you have in place means that your teams, as well as your business partners' teams, your commercial counterparties, have one set of paper to negotiate off of. And you are able to develop a key issues list because the volume is going to be not insignificant to understand and prioritize how you can actually negotiate these provisions and come to commercial agreements that make sense. Obviously, not many of the specific words in the standard contractual clauses can be negotiated. It's really more about the substance and the details of the transfers and the safeguards, but putting it all in one place and capturing other legal requirements all at once, we think is one of the best ways to try and reduce the additional churn that is likely to come about as a result of other laws and other requirements, whether it's in the United States, Asia, Latin America, Europe, or elsewhere. One of the other things that I think is particularly important for kind kind of post-SHRAMS 2 compliance is, and I talked about this earlier, is understanding your exposure to governmental process and requests for personal data. And I think that this is really important in the negotiation stage, because a lot of the driving animus for the issues that led to SHRAMS and SHRAMS 2, as well as that are reflected in the new clauses, are a concern about governmental collection of information. So understanding your posture with regards to that issue really will help respond to questions that you receive from counterparties, either sending you a DPA or requesting, or that with which you are requesting sign your new DPA. So that's something where a really robust understanding of your posture as a company will help cut down a lot of the conversations and make it more targeted to make sure that you're really talking about safeguards that are commensurate to the risks that you're actually facing as a business. And of course, this isn't all just about contracting. There's a good deal of this that is a healthy reminder to do internal housekeeping. Whether that's making sure that you have periodic reviews of your internal and external privacy policies, to make sure that you have a strategy around data mapping and understanding your data flows. This is something that we've known is needed, but is just articulated even more clearly by the new standard contractual clauses. Is just that you really need to understand the flow of data and the data processing that you both do yourself and that you contract with other entities to do. And in addition, to really understand the security posture that your company has in place, the technical safeguards that you use to protect personal data, and how you implement those in practice, because these are going to need to be reflected in the contractual commitments that you're making. So developing an understanding of what you feel comfortable saying and representing from a security perspective is going to be a vital part of this process. So this means more cross-team collaboration with your information security partners to make sure that you are all aligned around how you are going to talk about this and represent the company when either putting agreements out and imposing obligations on third parties, or when you receive such requests, how you can respond from language and template responses that you feel comfortable committing to. So pivoting before we run out of time to talk a little about some practical thoughts on some of the many good considerations and concerns that Karen raised about the highly dynamic framework in Asia, we wanted to talk about a couple steps that you can take to assess your exposure, and then some practical risk management steps for China. So first and foremost, Karen covered a number of new requirements in Asia that speak to the troubling trend of data localization. This is a really challenging topic for businesses from just a practical compliance perspective. The requirements may conflict across geos. They may lead to complexity with regards to infrastructure in the cloud, as well as difficulties of implementing consistent policies and procedures. So we kind of recommend for data localization, the first step really is understanding what applies to you. Understanding, is this something that really does strictly apply to your business? Are you within one of these regulated sectors? Or are these data localization requirements somewhat softer in terms of their strict applicability? And are they more recommendations? Are they sector specific only? Do you have to do it, or do only local partners that are based in the country have to do it? Is the applicability driven by whether you're offering services to individuals within that country or otherwise? And one of the primary signaling devices that companies can look to demonstrate both awareness of and consideration for APEC issues in privacy and data protection is the APEC CBPR system. And this is a certification system that facilitates data flows and that has a number of countries signed on and kind of acknowledging the sufficiency and adequacy of this process, including the US, Mexico, Canada, Japan, Singapore, South Korea, Australia, as well as the Philippines and some others. This is something that I think is a really great way of demonstrating not only that does a company pay attention to and reflect, of course, its obligations under GDPR, as we've talked about, the implementation of those contractual requirements, but an outward-facing commitment and demonstration of a company's global presence, as well as how it thinks about and responds to the diversity of legal questions raised by the broader Asia Pacific data protection legal landscape. Turning next to China, thinking about just how to kind of manage the risk under the myriad legal requirements covered by Karen's presentation. We don't have all of the kind of implementing regulations that are going to be needed to understand the data security law. There's no substitute for staying tuned. Certainly in future Mayor Brown webinars, I'm sure we will discuss those in more detail. But similar thoughts go into it. Understand your data processing in China, think about data mapping, understand whether there are sector-specific rules that apply to you, and this is particularly significant in China, especially in certain contexts, whether e-commerce, finance, healthcare, or in particular AI. And then understand the specific considerations and the specific sensitivities that there are with regards to transferring data that was collected in China overseas, and the exposure that that data may have to law enforcement access abroad. This is a similar sensitivity that exists in the European context, but the applicability of the law is slightly different. A good example for this is in the cybersecurity law, which has been around for a few years. The implementing cross-border data transfer measures looked at this question, and while the cybersecurity law was and has been much reported as a data localization obligation, in fact, some of these data transfer measures which implemented the cybersecurity law set out only two key areas for a company that is classified as a network operator, which is a lower degree of sensitivity than a critical information infrastructure operator, in order to transfer personal data across borders. And those are, one, to conduct and document security assessments, and two, to ensure that you have consent for cross-border transfer of personal data. We think that these are proactive steps that any company that is collecting personal information in China and transferring it cross-border should take, regardless of whether they've been classified a network operator or not. The definition of network operator is quite broad, so almost any entity that is doing business in China may reasonably view itself as subject to those obligations. But these are good steps to take in any event, whether even just internally to make sure that you understand the posture, both from a legal and consent perspective, but also from a technical perspective with regards to how you protect information to have in place. Of course, if your company is subject to stricter rules, such as being designated critical information infrastructure in China, more and difficult, more strict obligations may apply to you. And so keeping an eye on that and working with your NGO teams to understand the risk associated with those designations and how likely they are is an important way of staying ahead of your obligations, not just under the cybersecurity law, but under these new laws that are coming into place, whether the data security law or the draft personal information protection law, which we are keeping an eye towards later this year. With that, we hope that this has been helpful and that some of these practical steps are things that you can take back and think about with your business. And I will turn it back to Oliver to lead a question and answer session.
Thanks very much, Vivek. So many organizations must have a lot of questions about how they're going to comply with these requirements and also what changes need to be made in terms of the assessment they need to do and the data transfer requirements they need to comply with. So I'd like to ask each of our panelists a question. Ulrich, you mentioned that as far as the EU requirements are concerned, that businesses should conduct not only an assessment of the laws of the country to which data is being imported, but also of the practices that take place in that country. What is the significance of the assessment that has to be done with respect to the practices in the importing country?
Thanks for the question, Oliver. I think the requirement to not only assess local laws, but also local practices can actually cut both ways. So let's assume a cloud services provider can demonstrate that it has never experienced that law enforcement agencies or other authorities access certain categories of data, even though they could by virtue of the law. Then this might provide an argument that supplementary measures to be adopted may be less strong. On the contrary, if the law would not allow data access, but authorities would nevertheless demand access in practice, then this would be a call for the implementation of strong supplementary measures. And I think this is not as far-fetched as it may seem at first glance. For example, in Germany, we've seen cases where law enforcement has been requesting access to data relying on the wrong legal basis. For example, relying on a legal basis applicable to telecommunication providers when actually addressing a provider of telemedia services and not telecommunication services. Or law enforcement agencies requesting access to several data points, while the legal basis actually only allows for the disclosure of certain of these requested data points. So I think this is a real concern for companies out there.
Thanks very much, Ulrich. Karen, you mentioned the draft Personal Information Protection Law, which expands the scope of requirements as far as China is concerned. To what extent do foreign companies with no presence in China need to worry about the draft Personal Information Protection Law?
Well, not surprisingly, China has drafted the Personal Information Protection Law in order to have extraterritorial effect. So it specifically applies to anyone outside China that processes personal data of individuals within China. If it is for the purposes of providing products or services to individuals within China, or to analyze and evaluate the behavior of individuals in China, or any other circumstances stipulated by localized regulations, which is sort of a broad catch-all. So you can see that there are some parallels with the GDPR, but the wording is drafted a bit broader. So for example, it could be that even if a foreign company is not specifically targeting individuals in China, and it doesn't have a Chinese website, it's not targeting advertisements to consumers in China, it just allows global delivery, the company could still be subject to the Personal Information Protection Law as it is processing personal data of an individual in China for the purposes of delivering a product that they've ordered. The draft law also requires any data controller outside of China to establish a dedicated office or appoint a representative within China to be responsible for protection of personal information. Data processors that are located overseas that process personal information on behalf of data controllers that are caught by the Personal Information Protection Law could also be subject to certain requirements under the Personal Information Protection Law, including the need to establish a local presence. Lastly, it's also important to note that the draft Personal Information Protection Law has specifically stated that where any foreign organization or person engages in processing activities that is seen as harming personal information rights and interests of Chinese citizens or endangering national security or public interest, that they can be put on a blacklist and prevented from collecting personal information in China.
That sounds very serious. Thank you very much, Karen, for that. Turning now to Vivek. Vivek, thanks very much for your part of the presentation. You gave us some really good tips there. As you said, this whole process is exhausting and we feel clients pay. How can clients avoid the endless cycle of recontracting for every new privacy law?
Yeah, this is a tough one. I think that there's two things to do here. One, as I mentioned, I think during the presentation, it's understanding your posture really well, understanding what you do as a business that may trigger extra consideration under these legal frameworks. I think a great example is in the United States in Virginia, where they enacted a law that's similar to GDPR. A novel requirement in the United States is that you obtain consent before collecting sensitive data, and the sensitive data definition tracks GDPR. So, that's a kind of an issues list type thing that companies may not have, especially US-centric companies, may not have done already. So just understanding what you are doing that tracks or creates potential additional legal issues or exposure under traditional privacy legal frameworks will put you in a good position to understand what you can commit to externally. Understanding that allows you to have forward-looking contractual representations. Now, I say that, and I say that because I think that it's a good way to understand what you do as a business and how you can represent yourself consistently over time. But I have to mention that there's no accounting for these laws that kind of come out of the blue, such as CCPA, which completely turn privacy compliance in the United States on its head because it doesn't relate to traditional comprehensive privacy or data protection frameworks or norms, but turns instead on an entirely different concept of do not sell and sharing of personal information between entities in that context. So, you know, I hate to end on a bit of a gloomy note, but I think that the reality is that while I think a diligent, responsible company will understand its posture, understand certain key data collection and processing aspects of its business, there is probably no single answer as to how to prevent the potential for recontracting over time, other than doing one's level best to try and get ahead of it.
Thank you, Vivek. Well, thank you very much for joining us today on our webinar on addressing the International Data Transfer Challenge. If you have any questions about the content of our webinar, feel free to get in touch with any of us using the contact details on the screen. Until then, I'd like to thank you very much for joining our webinar, and we look forward to speaking to you on the next one. Goodbye.